This is Kathleen Bonzik, and the following is employment non-compete agreements. Employment non-compete agreements are grounded in basic contract law, and as such, basic tenets including offer, acceptance, and consideration are applicable. An employment non-compete agreement may be a particular clause in a larger document that an employer presents an employee with, or conversely, it may be a separate contract entirely. It is a type of restrictive covenant, as is a non-solicitation agreement or a confidentiality agreement that an employer may also require its employees to execute. Essentially, it is a promise made by one party, here the employee, not to do something against the other party, the employer. What is the purpose of a non-compete agreement? The first thing to consider is that a non-compete agreement deals with future events, and the overall purpose is to protect the employer from having an employee go into direct competition with it at some point in the future when the employee separates from that employer's operations. An employer may require its employees to execute a non-compete agreement to prevent or deter them from either setting up shop and competing against them directly, or joining an existing competing company after they leave. Example, suppose ABC Healthcare Incorporated has recently hired a new physician, Dr. James Smith. As a condition of his employment, Dr. Smith is required to sign a non-compete agreement, and per the terms of this contract, he promises he will not go into business for himself within 20 miles from ABC's operation for a period of 6 months' time after leaving ABC's employment. Assuming that this contract is enforceable on day 6 months and 1 day after he leaves ABC's employment, Dr. Smith is free to set up shop for himself and go into competition. What are the effects of a non-compete agreement? Each state in the country maintains specific laws and standards as to whether it does enforce these agreements and the extent to which they are so enforceable in their jurisdictions. Reasonability is an inquiry that courts will make when reviewing these contracts. A court may deem the non-compete agreement to be legally binding and enforceable so long as it contains reasonable limitations as to the time period and geographical area in which the employee may not compete. Conversely, an overly broad non-compete agreement that severely prevents an employee from working might not be upheld even in those jurisdictions that do recognize their validity. This is Kathleen Bonzik. Thank you for listening.